Yashwan, good morning. How are you? Very good. Yes, please. Good morning to all of you. I hope everybody is fine. So we are here to continue with our discussion on various provisions of Companies Act. Good morning, Pujita. And I hope you all are studying law properly. Srinidhi, good morning. Not only you all are studying properly, but you must have gone through the RTPs. Do all the questions from RTPs. It's very important, especially the recent RTP which has been released by the institute May 24. Do that RTP properly, and all the topics that I have revised in the crash course lectures, do them. Do the other topics which were done in the regular course. So today I wanted to take up an important discussion on meetings chapter. Last lecture we were discussing about the debentures and shares. In case if you want me to discuss any specific section, I will do that from debentures and shares afterwards. But first, I wanted to take up meetings, which is your lesson number 7, because I feel that's an important chapter. So if you would have observed that in the course of these crash course lectures, I have been discussing all important chapters, because see, it's a small duration in which we have to cover so many things. So all the important things we are doing first. Okay. So today also I want to discuss meetings, which is a very important topic. Management and administration. That is your chapter number 7 as per the Bear Act, in which I am starting with meetings provisions. So in your study module, your institute module, you people can directly come to meetings chapter, because see, initially if you see, there are provisions given for the members topic also. Membership, who can become member, partnership firm cannot become member. Those are manageable chapters or easy chapters, but meetings is something which is requiring detailed explanation. So I'm just starting with meetings today. So if you can come to directly on module page number just a minute, I'll open the document. Yeah, so you can directly come to page number 7.30, meetings, prerequisites for meetings. If you can come there, I will start with my discussion. Prerequisites for meetings. Can I proceed? Everybody there on page 7.30? Yes, sir. Thumbs up. Come on. Okay. Very good. Sushmita. Hi. So meetings we are starting. See, what are the different types of meetings in the company? Meetings can be of two types: general meetings and board meetings. Okay. If I have to show you that meetings in a company can be broadly divided into two types. You can see on the board, we are starting with meetings chapter today. So meetings can be of two types. You have the general meetings and you have the board meetings. In your inter-CA syllabus, they have kept only general meetings, not the board meetings. Of course, but I will tell you few things about both. As far as the general meetings are concerned, these are called shareholders meetings. These are shareholders meetings. Whereas the board meetings are the meetings of board of directors, BODs. Okay. They are the meetings of board of directors, BOD meetings. Whereas as far as the general meetings are concerned, there are three types of general meetings. Okay. You have the annual general meeting, which I will cover now. In section number 96, the provisions are given regarding the AGM. In EGM, that is extraordinary general meeting, there is section number 100 provision given. So we'll cover two major sections now. I'll cover EGM also, I'll cover AGM also. And then there is one more meeting, but that does not have any legal provision. That meeting, general meeting, is called as class meeting. That is called as class meeting. That does not have any legal provision, but we will still discuss it. So meetings can be of two types: general meeting, extraordinary general meeting, and class meeting. This is the sequence of the chapter. So in module page number 7.31, if you can see, whatever I've written in the chart, the same things are written there. If you see, there is a meeting called class meeting in the module page number 7.31. There is a meeting called class meeting. Now, technically speaking, class meetings are meetings of minorities, class meetings are meetings of minorities, such as creditors, preference shareholders, those whenever their rights are affected, minority rights, whenever they are affected, that time the class meetings are called upon, So minorities themselves can call class meetings. So preference shareholders, if you don't pay them preference dividend at the time of making the payment, or if you don't redeem the preference shares, if you don't redeem the debentures properly, they can call for a class meeting. So class meetings are mainly minority meetings. Okay, and there is no legal provision in company law. Even if you read the entire company law, apart from a small mention somewhere, there is no legal provision in Companies Act regarding class meeting. Then general meetings can be of two types, AGM and EGM. Apart from class meeting, you have AGM, EGM. So AGM is the annual general meeting and EGM is the extraordinary meeting. Both are important meetings, both are mandatory type of meetings. The only thing is, when shareholders cannot wait till the AGM takes place, then they call for a EGM, extraordinary general meeting. Okay. And if shareholders can wait, or suppose if there's something that has to be discussed in the AGM, let me tell you, four important businesses are discussed at the AGM. First is the declaration of the dividend, approval of the annual financial statements, adoption of the accounts by the shareholders. Then you have the appointment of auditors, and not only appointment of auditors, but even their remuneration can be fixed. at the AGM itself, remuneration fixation of the auditors. Then you have appointment of directors and of course fixation of their remuneration as well. These are the 4 important transactions that we discussed in the AGM. Okay, they are normally discussed in the AGM. And whenever any decision making happens in the AGM, before conduct of the meeting, first you have to circulate the notice. So if you see the next point, section 101 says that 21 days, underline, at least 21 days clear notice, or at least 21 clear days notice is required to be sent. Okay, so the company has to send at least 21 days clear notice to all its members in writing and through the electronic mode. Okay, through the electronic mode. What is going to be the contents of the notice? Okay, what is written inside the notice? The notice will always mention the place where the meeting is to be conducted, the date, the day, the hour when the meeting will be taking place, and what kind of business will be transacted. Okay, always remember that since you are sending a notice of a meeting which is going to take place in a future date, the grammar, the English that you should write in the notice should be always in future tense. Okay, so you have to always use future tense in the notice because the meeting is going to take place in the future. So you can use the future tense there. So place, day, hour, then the statement containing what kind of business we need to transact. Okay, and suppose if there is a special resolution to be passed, come on, you all know this provision, that if there is a special resolution to be passed, then can I say that you have to also send the explanatory statement, okay, along with the notice. So along with the notice, you can send the explanatory statement as well if there's a special resolution required to be passed. Okay, explanatory statement will give the details of all the special businesses to be transacted. Who are people who are entitled to receive the notice? Members, every member of the company, their legal representative. If the member is a deceased member, now he's not alive, so he will not, the notice cannot go to Yamraj, correct, sir? So it has to go to the legal representative. Auditors of the company, even auditors are entitled to receive the notice. And then the directors of the company. Okay, so notice has to be served to all the members, legal representative of deceased members. If there is any insolvent member, you can send it to the assignee of the insolvent member. Auditors, of course, you have to send the notice because they are the auditors, statutory auditors. And of course, to the directors, because in fact, directors convey the meeting. Directors are the people who are in charge of conducting the meeting. Many students have a confusion. Who conducts the meeting, sir? The directors conduct the meeting. Okay, even though it is a shareholder meeting, but it is conducted by directors. 21 clear days, what does it means? They had written there that the notice has to be sent 21 clear days before the conduct of the meeting. Okay, so what does the 21 days means? So 21 clear days means that the date when you dispatch the notice, okay, the date of dispatching the notice and the date of AGM, on the day on which the AGM is supposed to be held, these 2 days you don't have to count. Okay, so when you are sending 21 days clear notice, it has to be in between 21 clear days. The date of dispatch and the date of the meeting have to be excluded from the computation of 21 clear days. Okay, you can nowadays send the notice through electronic means. If it is a meeting, general meeting, you can send it via the electronic mode. So you can send it. There is a rule number 18 of the company's management and administration rules 2014. Please underline that rule number 18. Some rules I will make you underline because I feel that if you quote the rule number, it creates a good impression. You know, section we are writing 101, but if you write the rule number, nothing like it. So rule number 18 says that the notices are to be sent, and you know there is a method of sending the notice. You can send it via electronic means. So when I say electronic means, what does it means? You can use any secured computer program which is capable of securing the data, producing a confirmation, keeping the communication very much confidential. and very much addressed only to that particular member who is entitled to receive the notice. So you can use email communication for sending notice, but it should be, it's something like a secured email ID. Okay, secured communication is required. In the email, you can send the text message. You can type the text in the email body. You can send the email attachment. You can send some electronic link of a notification, and you can also send the URL address, the uniform resource locator address. The link you can copy in the email. Once the person clicks the link, the notice will open. Okay. Email should be addressed to every such person who is entitled to receive the notice. And this email ID should be the same email ID that the person uses for communicating with the depository. That means if the person invests in company, he must have given the same email ID to his stockbroker. So the same email ID has to be used for sending the notices. And the subject line of the email should be the name of the company. In the subject, you have to write that XYZ company, notice of XYZ Limited. And then you have to type the name, the meeting place, which kind of meeting you are conducting, EGM, AGM, place where it is conducted, date of the meeting schedule, etc. So all the requisite meeting related details you have to give to the prospective members who are going to come and attend the meeting. And then the notice should be sent in a PDF format, portable document format, PDF. And it should be, the email which you are sending should be non-editable attachment. It should have a non-editable attachment, underline non-editable attachment. That means you cannot, the shareholder cannot do any alterations in the attachment. It's a statutory notice. It's a notice coming from a corporate. So you have to make sure that it's a read-only message, not a editable message. So it should not have that edit log feature. Okay, notice should not be having the editable attachment. So the link or the instructions that the recipient is downloading from by using that email software should not be editable at all. Okay, non-editable. So please make a note of that it should be non-editable. And who can send the notice? Either company secretary, or you can even appoint a register and transfer agent, RTA. We call them as RTA, register and transfer agent. Even they can also help the company in sending bulk email. Nowadays, see, when you send emails, you use the bulk email facility, which even Gmail provides. So in one shot only, you can shoot the notice to all the members, whoever names are written. So the RTA will be authorized for helping you to send bulk emails to all the members. Okay, you can also place your notice on the website. Important point. Just like financial statements can be placed on the website, even notices can be placed on the website. Okay, so you can send it via bulk email facility on the website. If suppose a shareholder does not receive the notice accidentally, so by chance the notice was not delivered to him, by chance the the email address which was provided by him was not correct, anything can happen, correct, sir? So section 101 further states in the subsection number 4 that any accidental omission to give notice or non-receipt of the notice by any member or other person who are entitled to receive such notice for any meeting shall not invalidate. Sir, this point I had also spoken in my regular classes, underline. If you don't receive the notice, it doesn't mean that the meeting gets null and void, invalidated, or whatever resolutions are passed in the meeting, they get invalidated. No, sir. They still are valid. So the notice does not, the non-receipt of the notice does not invalidates the proceedings of the meeting, but it is the onus of the company. It is on the company, it is the burden. Onus means the burden is on the company to prove it that it was not a deliberate attempt of not sending a notice to a concerned shareholder. Accidentally, it was not sent by some mistake. Email ID was not provided correct or some. So company will have to justify this to the shareholder. Okay, so case study can come from here. Marking it, this section 101 subsection 4, marking important for case study. Marking important for case study. Yes, sir. Tell me, are you following? Everybody is clear, sir? All the people are understanding? So we have started with a topic called meetings. Yes, please thumbs up, everyone. Yes, sir. All the people. Fantastic. Where is Shashank? Shashank, can you read one case study? 7.34 illustration number 4. Are you there?
Yes, sir. Yes, sir.
Hmm.
Mr. Abhinav, a member of Elixir Logistics Limited, filed a complaint against the company for not serving him a notice for attending the AGM of the company. The AGM. The company, in turn, provided the proof that they had sent the notice by way of an email to Mr. Abhinav, inviting him to attend the AGM of the company. Mr. Abhinav alleges that he never received the email. State whether the company is liable to be guilty for contravening the provisions of Section 101 of the Companies Act 2013, read with applicable rules.
So just now I was explaining you this point, 101 subsection number 4, that the onus of the proof is on the company, and if the company can prove it that the member had not given a proper email ID or it was some technical error, then it would not invalidate the proceedings of the meetings. Okay. So let's see what Abhinav can get the remedy from here.
As per Rule 18 of the Companies Management and Administration Rules 2014, the company's obligation shall be satisfied when it transmits the email, and the company shall not be held responsible for a failure in transmission beyond its control. Also, Rule 18 prescribes if a member is entitled to receive the notice fails to provide or update relevant email address to the company or to the depository participant, as the case may be, company shall not be in default for non-delivering notice via email. Accordingly, Elixir Logistics Limited shall not be held guilty if there was a failure in transmission beyond its control or in case where Mr. Abhinav did not update his email address.
I just like that statement, beyond its control. 2 or 3 times they have used that statement, beyond its control. Now, what can the company do if the service providers only the things are beyond its control? The service providers communication channels are not up to the mark, so that company cannot do anything about it. Okay, beyond its control. Or if the Mr. Abhinav has not updated his email address with the company records, he has not provided the same email address as he has given it to the depository participant where he's operating his demat account. So then the company can't do anything about it. Tell me, can Abhinav say that the decisions that were taken in the meeting are null and void? Can he say like that? Can Abhinav say like that? No, sir. Very good. Yeah, because it is not the mistake of the company if the company proves to the satisfaction of Mr. Abhinav. Very good. Yes, sir. Then coming to the next point, shorter notice less than 21 days. Please underline the heading, section 101, subsection 1, proviso. So this is proviso to section 101 and very important, mark it very, very important. Sir, why does the company gives 21 days time, 21 clear days time period for the shareholder to read the notice? Because shareholder can read the contents of the notice, he can understand the situation that is there, he can question the company on the basis of the notice. Okay, but if the notice has to be served, a less than 21 days time period is also permissible. It's not necessary that the company has to give 21 clear days only. Even if it can be served in 14 days. For your kind information, if this would have been a meeting of a Section 8 company, if this would have been a meeting of Section 8 company, then the notice could have been given in 14 days also. Okay, so the time limit of 21 days can be substituted as 14 days if it was a Section 8 company meeting, non-profit organization. So sometimes, members can demand for a shorter notice period also, but then all the members should be okay with it. And even the company can demand for a shorter notice. but then all the members have to be okay with it. Okay. Now, when I'm saying okay with it, it means that they have to pass a vote stating that less than 21 days period also we are comfortable. As long as you give us at least minimum 7 days, it is enough for us. So no need to wait for 21 clear days. So examiner can make a question that can 21 days be reduced to a shorter period? And if the answer comes yes, then what is the legal provision for that? So I think the answer is given here, that when the in the meeting for the annual general meeting to be conducted, if 95, not less than 95% of the members who are entitled to vote, please underline point number 1, in case of an annual general meeting, not less than 95% of the members who are entitled to vote thereat. So if you take approval from 95% members, and if they say, okay, let's reduce 21 days to 14 days, okay, then they can reduce it. So 21 days can be reduced to lesser period, shorter period, provided you are taking approval from 95% members. 95%. Second thing, other than a general meeting, then you have to take if the company is having share capital, and if the company is not having share capital, then there are two classifications. So for annual general meeting, straight away 95% of the members who are entitled to vote, simple provision is written. But if it is other than the general meeting, then in that case, it is 95% of the paid up share capital, provided company is having share capital. Okay, that majority members should be formed, and that majority who are entitled to vote should also represent not, so there is an and in between. Huh? The company is having paid up share capital, so there is an and in between. Circle the and. Circle that and. So 95% of the paid up share capital, also circle the and, the members who are entitled to vote. If this many members give their approval, then in case of any other general meeting also, we can provide a shorter notice. So other general meeting can be extraordinary general meeting. Other than the general meeting, it can be extraordinary general meeting. Then 95% will come. But this will not apply to class meeting. You know why? Because entitled to vote is written. Preference shareholder and debenture holder are not entitled. They don't have voting rights. Please remember. Huh? So you have to connect the points and study. Preference and debenture holders, creditors, it will not apply to class meetings, because class meeting, these members don't only have the voting rights, so they are not entitled to vote. So entitled to vote condition only fails there. Okay. And if the company does not have a share capital, then 95% of the total voting power exercisable at that meeting. So it is 95% of the paid up share capital. If company has share capital, then take 95% of paid up capital. And if company does not have share capital, then you take 95% of the total voting power which is exercisable at that meeting. This much, if you get the votes from the members, then 21 days can be reduced to a shorter period also. Tell me, have you understood or not? So this is detailed discussion on notice. I would want Shashank to read just one more illustration 5 and mark it important illustration. Mark it
The
important
paid up,
illustration.
the paid up share capital of Akash Soaps Limited is rupees 50 lakh divided into 5 lakh shares of rupees 10 each. The directors of the company are desirous of calling an extraordinary general meeting by giving a shorter notice, which is less than 21 days. 60% of the members holding the shares worth rupees 40 lakh accorded their consent by electronic mode to the shorter notice. Whether AGM can be held validly called.
So tell me, 60% of the members were holding 40 lakhs. So the company's total share capital is 50 lakhs. Out of that, if the members are holding 60% is holding 40 lakhs, so majority is there. See, majority comes when it is more than 50% in company law. Okay. So majority is there, that 60% are holding. And this company is having share capital also. That means we have to see the condition for share capital. So we have to take 95% of the paid up share capital. Now you tell me paid up share capital is 50 lakhs. Where is my calculator? If you take 95% of that, 50 lakhs, 95% of 50 lakhs, it will come to 47 lakhs and 50,000. Yes, very good. I also gave the same answer, Ramesh. 47 lakhs and 50,000. So you have to take 95% of that. Okay. But here only 40 lakh rupees paid up share capital is held by them. The 60% member are holding 40 lakhs. So 40 divided by 50 comes to 80%. Don't use calculator. Na? This is easy calculation. So 80% it comes to. So can I say 80% is less than 95%? That means now meeting cannot be, EGM cannot be called by a shorter notice. That means you have to give 21 days clear notice only. Have you understood the calculation, everybody? Everybody is clear with the calculation, sir? Yes, sir. Yes, very good. Fantastic. Very good. Sushmita, Shashank, very good. Trupti. Yes, Shashank, can you read the answer?
In the above case, the consent to call the EGM by a shorter notice has been accorded by 60% of members holding the shares worth rupees 40 lakh, which works to 80%, whereas the requirement is the majority in number of members who represent not less than 95% of paid up share capital, which gives them a right to vote in the meeting. Shareholders holding shares worth rupees 47,50,000 must consent for a shorter notice. Therefore, the EGM cannot be validly called and held.
So early in
That's
the
right.
morning, we discussed two very important case studies. Okay, that's it, Shashank, it's done. So early in the morning, we discussed illustration number 4 and 5. Both I feel are important. And 5 I'm marking extremely important. This 95% calculation, it is extremely important. So for AGM, it is 95% of the voting power. And for other meeting like EGM, 95% of paid up share capital. If the company has share capital, company does not have a share capital, then it is 95% of the voting powers. For for class meeting, 21 clear days are compulsory. No, it's not like that. For class meeting also shorter notice can be given. Okay. So 21 clear days are not compulsory even for class meeting, because class meeting also falls under general meeting. So the answer is no, it's not compulsory. Have I answered your question? Shorter notice can be given. Yes, sir. Can we go to the next point? Explanatory statement. Who remembers what is explanatory statement? What is explanatory statement, sir? Whenever company is passing any special resolution, can I say you have to, whenever the company is transacting any special business, so then you will have to call the general meeting by giving a notice, and along with that you have to send a copy of explanatory statement. So explanatory statement must specify that what is the nature of concern to be transacted, what kind of business will be there, what is the financial interest of the people who are involved in the transaction. Okay, and what is the financial interest in respect of every director and manager, key management person, relatives, any other information that you want to give to all the members about the facts that will enable the member to understand the meaning, the scope, and the implications of the items of business and the decisions that will be taken in the meeting by passing a special resolution. So explanatory statement is very important. 102 section. Further, the businesses that can be transacted in the meeting can be classified into ordinary business and special business, OB and SB, ordinary and special. In the starting of the lecture itself, I already told you what are the 4 types of ordinary businesses. So financial statement consideration, along with board report and auditor's report, declaration of dividend, appointment of director, auditor appointment, fixation of their remuneration. These are all ordinary businesses, and they will always be conducted in the AGM. So all businesses that are transacted at the thereat except the ones above which are special businesses. So in AGM, if you want to transact special business also, you can transact, but ordinary businesses will remain only 4. In the AGM, ordinary businesses are only 4. Rest all businesses will be special businesses. And tell me, for special business, we will pass a special resolution where greater than equal to 75% voting is required in the favor of the transaction. And not only that, the ordinary business, more than 50% of the voting is required in favor of the transaction. And let me also tell you one more thing, that in case of EGM, only special businesses can be transacted. Please underline that point. At the EGM, every business transacted is a special business. Okay. An explanatory statement is not required for transacting ordinary business. This is also MCQ type questions. MCQ type questions. Then if you come down a little bit, quorum. What is quorum, sir? Quorum of the meeting is the minimum number of members who are present. Minimum number of members who must be personally present to constitute a valid meeting is called quorum. For public company and private company, how much is the quorum? So for private company, I will read first. 2 members who are personally present constitute the quorum. Can private company have more than 2 members as quorum? Only if their articles of association provide for a larger number. Okay. If the articles of association of a private company provide for a larger number, then they can have a larger quorum also. And can a public company have a quorum of how many members? Public company, if there are up to 1,000 members, then the quorum will be 5 members. If a public company has 1,000 members, quorum will be 5 members. If they are more than 1,000 but up to 5,000, then quorum will be 15 members. And if there are exceeding 5,000, then quorum will be 30 members who are personally present. So this constitutes the quorum. Members who are personally present, which are mentioned above, refers to only those members who are entitled to vote on the every agenda of the meeting. Okay. So only the members who have voting rights. Members personally present does not means that if you bring your child also along with you, or he's a small minor and he's not a member, suppose, in the company, then that fellow is a member personally present. So like this, our country has so much of population. So if we take all our neighbors, all our, people who are living in our vicinity, they are also personally present, but that does not constitute a quorum. So quorum means somebody, members who are personally present, who are entitled to vote. Okay, so if you are entitled to vote, then only you are called as quorum. Have you understood this point? Yes, sir. Then if quorum is not present, yes, sir. If quorum is not present, then what happens? Then the meeting gets adjourned. Okay. If quorum is not present, then the meeting gets adjourned for half an hour. For 30 minutes, you can adjourn the meeting. And then if the meeting gets adjourned, then it is adjourned to the next week, same time, same place. What is the difference between adjournment and postponement? I told you that if the meeting is not happened only, it is called postponement to the next duration. But if the meeting happened but could not get completed, then it is called adjournment. Okay, remember, don't call adjournment as postponement. Postponement meeting did not take place only. It was scheduled but did not take place. It got postponed. But adjournment signifies that the meeting, took place, the meeting took place, but since the quorum was not present or due to some reason, sometimes the people start fighting also. The atmosphere in the meeting becomes, heated up. So heated argument starts. So that could be also one more reasons why the meeting gets adjourned. So in that case, the meeting gets adjourned to the same day, in the next week, same time, same place, or sometimes at other place also, and such other time as the board may determine. Okay. And if the meeting is called by requisitionist under section 100, the requisitionist meaning the people who requisition an EGM, requisitioning meaning calling for EGM, section 100, that meeting gets cancelled, that does not get adjourned. So basically speaking, the adjournment point only applies to the annual general meeting, not to the extraordinary general meeting. Okay, remember. So meeting gets adjourned. And in case of the adjourned meeting, the change of day, place, the company shall give a not less than 3 days notice either to the member directly or by publishing in the advertisement newspaper of one English medium and one vernacular medium, whichever is in circulation. Vernacular medium is the language which is usually of that place where the registered office of the company is situated. So if you want to give any notice of the adjourned meeting to the members, it should be at least 3 days notice, not less than 3 days. And if the quorum is not present in the adjourned meeting also, members are only shameless, sir. They are not coming only for the meeting. They want shares, but they don't want to attend meeting. That's wrong, sir. Okay. But then all shareholders are like that. Even I am like that. I never go for any meetings, I don't get time. You people, full day I'm teaching. So where will I go? And my practice is going on. Where will I go and attend meetings? Okay. So if quorum is not present in the adjourned meeting within half an hour also, then the members who are present in the meeting constitute the quorum. So whoever is present in the meeting, that person itself constitutes the quorum. Have you understood or not? Tell me, is the quorum provision clear, everybody? So we discussed quorum, which is section number 103. We discussed the ordinary business, special business, explanatory statement, 102 section. We discussed notice, which is 101 section. Okay. So all these section numbers are damn important. Like I am expecting good questions from meeting chapter. The company law is all about meetings. Yeah, Shashank, illustration number 6. Can you read, please?
There are 54 members in Nice Games Private Limited. The company called its AGM on Friday, 1st July 2022 at 2 p.m. at its registered office. There were 28 members present till 2:30 p.m. at the venue of the EGM. The chairman of the meeting proceeded to initiate and pass the resolution after observing due process. Comment whether the meeting took place as per the provisions of the Companies Act 2013.
What is happening here? There's a Nice Games Private Limited. Okay. The name of the company is Nice. Plus they are playing games also. Okay. The company called its annual general meeting on Friday. Is Friday weekend, sir? Why they are calling annual general meeting on Friday? Weekend, how will members come? Should call on some weekday and look at the time. Friday 2 p.m. All members are relaxing and they are calling for annual general meeting. So till 2:30 p.m., 28 members were present. Okay. Till 2:30 p.m., how many members were present? 28 members. So can I say it means that there are more than 50% members present? Because if there are 54 members, divide by 2, 27. So there are 28, meaning majority members are present till 2:30. The chairman of the meeting proceeded to initiate the meeting and pass resolutions after observing the due process. So resolutions were passed. Now you have to decide whether the meeting took place as per the provisions of the Companies Act. So I think everything is going fine. Like meeting took place at the registered office. Okay, annual general meeting should always happen at the registered office of the company. If registered office is small, like Ambani's shareholders are 10 lakh shareholders will come. So registered office will become insufficient. So in the vicinity area, in the same city or the town where the registered office is situated. So majority members were present And this is a private limited company. In private limited company, 2 members constitute quorum. So here 28 members have come. So that is also followed properly. All the due process were followed. So I don't think there is any contravention. And the meeting was scheduled properly. So I think the answer is yes, the meeting did not contravene to any of the provisions of the Companies Act. Yes or no? Do you agree with the answer, sir? Everybody? Yes. Read, Sashank. Yes, sir.
As per provisions of Section 103 of the Companies Act 2013, the quorum of a private limited company shall be 2 members personally present within half an hour from the time appointed for holding a general meeting of the company. Thus, the quorum for the AGM of Nice Games Private Limited was complied with, and the company has not contravened any of the provisions of the Companies Act 2013.
Tell me, have you understood or not? Now, sir, see, just like you people study accounting standards, even in company secretary codes, there are secretarial standards which are taught. Okay, secretarial standards. So I am marking question number 7 important because it is an application of a secretarial standard, SS. AS stands for accounting standard, AS2 inventory. But now we are discussing secretarial standard. So secretarial standard 2 is basically talking about general meetings. I would just want you to see a glimpse of secretarial standard. On as a note they have given on page number 7.39. Page number 7.39, they have given a note that the quorum should be present at all times throughout the meeting. If you see point number 2 of secretarial standard, they have given that quorum shall not only be present at the time of commencement of the meeting, but also while transacting the business, it should be present. Okay, so the throughout the meeting, the quorum has to be present. Otherwise, the transactions which were made without the presence of quorum will become null and void. Okay. This is what is not written in law. This is written in secretarial standard. And secretarial standard talk about the loopholes of the law. You know why secretarial standards are issued? If anything that is not written in law, I would say this way, that if anything is not written in law, then it has to be mentioned in the secretarial standard. And if secretarial standard says the same, then it is permissible, then it becomes legal. So wherever laws are silent, now see in law it is not written. And see law, so many things we read about quorum, but did I say anything that if the quorum is present, then it should be present from the start of the transaction till the end of the meeting? I did not say like that because it's not written only. How can I say? But that point is written in standard that if any transaction has to be discussed, then the quorum has to be present from the commencement of the meeting till the closure of the meeting. Okay, till all the transactions are discussed. If quorum was present for, let's take, there are 4 transactions. Quorum was present for 2 and the remaining 2 quorum was not present. That means the people left the meeting. Then those last 2 transactions will become null and void. Okay. So not only members have to be personally present, but they should be present throughout the course of the meeting. This clarity is given under Secretarial Standard 2 on general meeting. This clarity is not given by company law. Imagine, company law is not clear. So the Institute of Company Secretaries of India has to issue secretarial standards. So based on that, we will have question number 7. Yes, Shashank, read the question.
Abhay Lights and Sounds Limited has 2,300 members. The company called its AGM on Tuesday, 23rd August 2022 at 10:30 a.m. at its registered office situated in Connaught Place, New Delhi. On the day of the meeting, 18 members were personally present by 11 a.m. and the chairman proceeded to initiate the AGM. There were 5 special businesses to be discussed at the said meeting by 2:30 p.m. Agenda 1 to 3 had been discussed and appropriate resolutions were passed. However, due to some emergency, four of the members had to leave around 3 p.m. The chairman granted them the permission and proceeded to discuss agenda 4 and 5 and accordingly passed the resolution as per the consent of the remaining members. Comment whether the meeting is properly convened meeting as per the provisions of Section 103 of the Companies Act.
Sir, this is a public company. Tell me what is the number of quorum for public company having 2,300 members? If it is a public company having 2,000, that means there are more than 1,000. Yes, very good. More than 1,000, but up to 5,000. So 15 members. Everybody agrees. Srinidhi, very good. Yeah, Sushmita, 15 members. 15 members are quorum. So how many were present now here? Here you can see that there were total 18 members present. So validly the meeting was conducted because members were personally present. Okay. And then there were some 5 businesses that were transacted. Agenda 1, 2, and 3 were passed. Then due to some emergency, 4 members had to leave. Okay, 4 members. 4 members have to leave the meeting. Now, when 4 members left, so there was some emergency, maybe some girlfriend was calling, so they had to leave the meeting. So 4 members had to leave the meeting. So now they became how many members? 14 members. So 18 minus 4, 14. That means, can I say now the company law is silent on this point that if there are less than, if the quorum is present initially at the commencement, but if the quorum is not present till the closure, then what is the solution? So secretarial standard question is asked on secretarial standard 2, that if quorum is not present throughout the meeting and in between some members leave due to some emergency, then whatever agendas will be transacted after they have left, they will not be valid agendas. Correct or not? So I think since we have discussed now the secretarial standard point, you will be able to write the answer. Yes, Shashank, read the answer.
According to SS2, the quorum shall be present not only at the time of commencement of the meeting, but also while transacting business. In the above case, while the required quorum as per Section 103 was present at the time when the meeting started, the quorum was not present at the time of deciding agenda 4 and 5. Thus, where at time of transacting business the number of members is less than the quorum fixed for the meeting, the business cannot be transacted and shall be a nullity.
Everybody has understood this question, sir? Perfect. Please show thumbs up. Yes, sir. And mark it important question. That today 2 important questions we have done. One is this one, the presence of quorum, and the one question that we discussed was in that 95% calculation. Okay, voting power, shorter than 21 clear days. These two, 100% chances of coming in exam. Very, very important. I'm marking. So now, after having discussed the quorum, the notices, etc., we will discuss the chairman of the meeting. Okay, who is the chairman of the meeting? And of course, the board of directors will decide who is the chairman. Usually, the chairman of the meeting can be anybody from the board. But since this is general meeting going on, the chairman can be anybody elected from the members. So suppose if there are 15, 17, 18 members, like in the above question only, if I take the example of the above question, that there are 18 members. So members who are personally present in the company, they will decide, like one member has to be a chairman. Chairman, why they are appointed? You will say that, sir, if somebody is a chairman, why do you need to have a chairman? When you're selecting it from the members only, then all of them have equal rights. So why we are selecting chairman? So see, normally chairman is selected to make sure that he does not do any partiality with anybody. Suppose if there are 18 members and 9 members are saying yes, okay, and 9 members are saying no, like in the above case, there were 18 members. Then the chairman will have a second voting right. Then what chairman will say, finally, that will become the decision of the resolution. So chairman is generally appointed to act neutrally, to attain impartiality. Okay, no partiality should be there. So chairman will decide the whole conduct of the meeting, and if there is any tie situation, then chairman can give his casting vote and he can break the tie. Okay, chairman has the veto power. So casting vote power he has. So that is the reason why we elect the chairman. So in board meetings also we elect the chairman. In board meeting, yeah, same happens in Lok Sabha also. Yes, so the Lok Sabha speaker is also the same. You have seen that when the parties are fighting, opposition party, this fighting, that fighting. So Lok Sabha speaker will say, "Shant ho jao, shant ho jao." Okay, shant ho jao. So he has to make sure that the meeting is conducted in a disciplined manner. Yes, in a disciplined manner, the meeting should be conducted. So chairman has the veto power. So chairman can be demanded by poll. If the poll is demanded for election of the chairman, chairman can be elected by show of hands, and he shall continue to be the chairman of the meeting unless some other person is elected as a chairman by polling method. So chairman has to be there elected by polling method. He can be immediately elected. So poll can be called immediately for election of the chairman. Okay, remember, poll can be called immediately for election of the chairman. And the chairman has to maintain complete decorum. Underline the word decorum, powers of the chairman. So decorum meaning discipline. In the meeting, he has to maintain complete discipline. Decorum. So chairman has to maintain complete decorum in the meeting till the time the meeting is concluded. And chairman also will be responsible for executing the minutes of the meeting. He will help the company secretary to prepare the minutes of the meeting. And then chairman have the casting vote if the article of association provide. So what do you mean by casting vote? As I told you, casting vote is a second vote in case of a tie situation. So casting vote means in case of equality of the votes, where the transactions are being discussed at the meeting, the chairman of the meeting shall have a right to give a second vote, casting vote. And if there is no provision in the articles of association for the casting vote, this has to be specifically provided by the articles of association. An ordinary resolution on which there is an equality of votes will be deemed to be dropped. So if there is a equality of situation, probably again an ordinary resolution can be passed. But usually in all the companies nowadays, the chairman has the casting vote power given. So articles of association, even if you don't have that power by articles, you can incorporate that power in your articles of association. So usually 3 things you have to remember: that poll can be demanded immediately for chairman. Chairman is appointed to put casting votes, and he has to maintain complete decorum according to section 104. And he will also help the company secretary in preparation of the minutes. Okay, these are the important things what chairmen do in the meetings. Then comes the next point, proxy. Who is a proxy? Now, I don't know, somehow I feel this is an important section because till September 2023, the virtual meeting concept was going on till September 23, and just 6 months back I'm talking. Because of Corona, the general meetings were also happening virtually by electronic means. So if you have seen Reliance meeting, it happened by YouTube Live, Facebook Live, YouTube Live. Mukesh Ambani was only talking. So when meetings happen live, then probably you don't need a proxy because virtually you can, cast your votes. But then in that also there are conditions. Who can cast vote? 2% you should have shares in the company. Reliance, if I get 2%, I'll leave everything. I'll become sannyasi then, because 2% of Reliance is so much. So proxies are required when the shareholders cannot personally be present. If shareholders cannot personally be present, then proxies are needed. Correct or not? So if shareholders cannot go, then they can appoint their representative, proxies. Proxy does not have a right to speak, and proxy does not have a right to vote also, except for voting in polling methods. So proxy is nothing but he's a representative of the member. So basically he represents the member who is entitled to vote. So you have to appoint a proxy. If you cannot go in the general meeting, you have to send a proxy. Proxy does not have a right to speak at all on any kind of transaction, and he can only vote if it is a voting by polling method. I just want you to see the voting on page number 7.46. They have shown how voting happens. On page number 7.45, they have made one picture image. Can you see that picture? If you are seeing in the soft copy, then it is clear, like proper colorful picture. But if you're seeing in the hard copy, probably it will be black and white. So can you see that voting happens by show of hands? So members are showing hands like this, and then they can put it down, show hand, put it down, show hand, put it down. Cheating happens in show of hands. They're cheating. That's why show of hands is not a valid method. Although it is there, nobody can deny that show of hands meetings cannot be happening by show of hands. Yes, voting can be done by show of hands, but cheating is possible. Show of hands, putting your hand up, then putting down. So then the next method is electronic voting. So electronically you can vote. Then polling method, in Lok Sabha elections now polling will happen. So probably you people will go, and even I will also go. But your exams are there. How will you go? Your exams are there, correct? So let's see what institute does. Because they are snatching away your fundamental right of voting. No, sir, we will vote. Whether exam is there or not, in between holiday also we will go and we'll vote. Okay, let's see. So I will go, definitely. I will not keep my lectures. We have voting on 26th April. 26th April, so definitely exam is not there. It's starting in May. So very good, lucky, Anurag, you can vote. So polling method, yeah, same. Okay. So polling method, how will you vote, sir? You will be given options. Yes, same. So then why some students are demanding to postpone the exam after the new notification has come? If the voting, maybe probably in their place, it might be coinciding with the exam dates, correct? Na? Yes or no? Yeah, probably it might be coinciding with their exam dates. That's why. Yes, probably. Let's see. So then we are lucky. So voting by polling method. So the options will be given, BJP, Congress, and all other party, Samajwadi party. So that is called polling method. Poll booth is there, and you have to press the button. Yes, 7th May. So Bharat, any exams on that day? I'm yet to see the timetable. Any exam on 7th May or holiday? 9th 9th May tax paper. 7th May no exam, but 9th May tax paper. Oh God, tax paper. Okay, then you decide, Bharat. Then what will you do, Bharat? Will you go for voting or you'll not go? I want to take student. You'll not go for voting. But then this is like in 5 years once it happens. See, this was the case I was talking. Institute should think about it. I hope they will do something. Our president, yes. Okay, you're writing outside your home. Okay. Our president has requested examination committee. Are you aware of that? I'm sure you must be aware. Our president have requested examination committee to again reconsider the dates. Yes, sir. So probably, let's see. Our president is very supportive, student friendly president has come. Let's see. Okay, and then there is voting by postal ballot. So there are 4 options of voting. Postal ballot, ballot paper will be sent at your home. Okay. And you have to give your votes and then courier the ballot paper again to the company. So there are four methods of voting in general meetings. Tell me, what are the 4 methods of voting in general meeting? 107, 108, 109, and 110 sections. Show of hands, electronic means, voting by poll, and voting by postal ballot. Okay, these are the 4 ways by which you can do voting in the meetings. And votes cast by shareholders will be the decisive votes. They will be the decision votes whether the proposed business is transacted or not. And always remember that when you're voting, there has to be some motion kept before the vote. So motion means proposal. Okay. What does the word motion means? The equity shareholder has a right to vote for every motion. On 7.45, it is written that motion means not the loose motion. Okay. The motion means the proposal. So every proposal will be kept before the equity shareholder, like appointment of auditor, appointment of director. Okay, and on that you have to vote. So equity shareholder has the entitled to vote on every motion. Circle the word motion and write there proposal. Okay, and so these are the 4 methods of voting. I'll come to these 4 methods in some time. Let me first complete proxy. So we were coming back to proxy. Let us discuss proxies first. So if the shareholder cannot go to vote, then he will send his authorized representative, who is called as a proxy. Correct or not? The shareholder can send his authorized representative called as a proxy. Okay, and proxy can act on behalf of the member not exceeding 50 and holding aggregate of not more than 10% of the total paid up share capital carrying voting rights. So this point is important, that a person can act as a proxy on behalf of members not exceeding 50. That means one person can become proxy of not more than 50 members. How many members you will become proxy, sir? You'll go mad. You'll not even remember whose proxy you are. Okay. So 50 is a very high limit that they have given. It's a very high limit actually, but it is acceptable that you can become proxy of not exceeding 50 members and holding aggregate not more than 10% of the total share capital of the company carrying voting right. That means if any member is having more than 10% of the total capital having voting rights, then the member has to be personally present. So he cannot send his proxy, you go and vote, because member has to be personally present here if the member is having more than 10% of the voting rights. So I'm marking this point important. Then there is a concept of joint proxy also. You can select a joint proxy. That means you can appoint 2 to 3 proxies at the same point of time. It's not necessary that you can only have one proxy. One member can have joint proxies. And that form number is very important, MGT 11 form. Please underline that form number. So MGT 11 form is the appointment of proxy form. Okay. So this is the instrument which you have to send to the company, MGT 11 form. And then proxies received 48 hours before the meeting will be valid even if the articles provide for a longer period. So the name of the proxies or the people who are going to act as representative of the shareholder should be known to the company 48 hours before the meeting. This is important point. 48 hours before the meeting. This is important point. So if in simple words, if we summarize everything, whatever discussion we did just now. So every member entitled to vote at the meeting of the company is entitled to inspect the proxies lodged. That means if you want to see who are acting as proxies, you can even inspect the proxy forms, MGT 11. For the purpose of inspection, minimum 3 days notice in writing should be given to the company. You can inspect by giving 3 days notice. Inspection by any member can be made during the period beginning 24 hours before the time fixed for the commencement of the meeting and ending at the conclusion of the meeting. This is a very ordinary point, nothing important from examination point of view. Yes, but inspection should happen during business hours. Underline the word business hour. What is business hour in company law? 9 a.m. to 6 p.m. 9 a.m. to 6 p.m. is called business hour. And if the person commits any default in the selection of proxies, then or maybe even the company can commit a default in consideration of the proxies, then every officer of the company who is defaulter will be liable to a 5,000 rupees penalty. And for the purpose of meeting invitations to appoint the proxy, a person or one of the members called specifying the invitation are issued at the company's expenses. So if suppose company is inviting some members to act as proxies, whatever stationery expenses, whatever invitation expenses happen, that company has to bear. To any member who is entitled to have the notice of the meeting sent to him and vote thereat by a proxy. Sometimes companies have to send notices to the proxies also, the valid proxy of the member. So whatever expenses happen, that will happen by the company. Company has to bear the expenses. So I think these are the provisions. Mainly the points that you have to remember for proxy is the definition of proxy, meaning then proxies are not entitled to speak. They are not entitled to vote except for polling method. And then you have to remember MGT 11 form. MGT 11 form, that is form number, is very important, instrument of proxy, and then it has to be sent 48 hours before the meeting. That is also important to remember. So these are the important things for proxy. And then penalty for officer 5,000 rupees, that you can remember. Any expense for appointment of proxy will be borne by the company, that also you can remember. So main points are important that you can remember. Tell me, is it clear or not? So let's discuss one case study on this. Illustration number 8. Joint shareholders. Illustration number 8. Yes, Shashank, Mr. Subramaniam, that one.
Suppose Mr. Subramaniam and Mrs. Sneha are joint shareholders of Sports Equipment Private Limited, holding 500 equity shares in respect of a particular special business being transacted at EGM of the company. Mr. Subramaniam is in favor of passing the resolution, whereas Mrs. Sneha does not favor the resolution. Decide how should the vote be casted in case of such situation arises.
Sir, whoever's name will be coming first in the register of members, whoever names come first in the register of members, that is the real decisive shareholder. So suppose there are two parties, Subramaniam and Mrs. Sneha. They are joint shareholders. Okay, assuming that they are husband-wife. So now if they are joint shareholders, even if they are not husband-wife, it's still okay. But they are jointly holding the shares. Now, whoever names comes first in the voting list in the shareholders register, that person name is first selected. Likewise happens in proxy also. Suppose if I'm appointing joint proxy, I've appointed 3 people as my proxy. So in MGT 11 form, whoever name I write first, that person has the entitlement of voting. So if you disagree with the other member, then their votes are not important, because what the first member whose name appears in the list says, that is important. Yes, please read the answer.
The voting in case of joint shareholders is done in the order of which is determined on the basis of the order in which their names appear in the register of members. The joint holders have a right to instruct the company as to the order in which their names shall appear in the register of members. Accordingly, in the case of Mr. Subramaniam and Miss Neha, it is to be seen as to whose name appears first in the register of members and then to decide whether the vote is casted in favor of the resolution or against it.
So I think it's a very simple provision that whoever comes first in the register of members, they need to vote first. Okay. And same goes, you please write there. Suppose this question is tilted and instead of this shareholder, they ask you proxies. So still answer remains the same. Whoever name comes in the order of seniority, that person can only entitled to vote. Okay. Consider a situation where director are also the shareholders of the company. So can director become shareholder of a company? Answer is yes. Even director hold qualification shares in the company. They may hold some more shares also in their personal capacity. But whenever a director is a shareholder, he should forget at the time of voting in the general meeting, he should forget that he is a director. He should not get influenced by the fact that he is the director. He should be influenced by the fact that as if he's an ordinary shareholder of the company. Yeah. Shashank, read the answer.
Directors, who are also the shareholders of the company, stand in a fiduciary relationship with the company in their capacity as directors. However, a director shall vote in the same manner as a common shareholder would have voted in a general meeting. Therefore, while casting his vote, he is not supposed to be influenced by the fact that he is one of the directors of the company.
So I told you the same thing, that he should not keep that thing in mind that, oh, I am the director, so I am going to pass votes as per my thinking, No. Even if you're a director, you have to still not get influenced by such facts. And voting by show of hands. Now coming to section 107, the different types of voting. So unless the voting is demanded by poll or electronic means, the voting is always done by show of hands at the first instance. The chairman of the meeting will pass resolution or otherwise by show of hands, and an entry to that effect will be made in the minutes book, shall be the conclusive evidence that the resolution has been passed. So, normally they appoint a scrutinizer who will be present in the meeting throughout. A scrutinizer can be any company law expert, any CA, any CS. Nowadays CS, they see CS is a very important part of the meeting. One cannot ignore the fact that a meeting can be conducted without having a company secretary. It is must to have a CS. So even the CS will act as a scrutinizer, and whatever the votes are passed by show of hands, he keeps on writing in a book that, okay, this person voted in favor, because the name of all the members who are present is there in the register of members. So he will keep on tick marking and he will say that the vote has been passed. So afterwards, even if the hand is kept down, still once the hand was up, and if the scrutinizer has tick mark, that means it is voted. So show of hands is the criteria for voting. Can insolvent shareholder vote at the general body meeting or general meeting by show of hands? Why not? The fact that you are insolvent does not denies you from voting. But if suppose any monetary transaction has to happen with the insolvent member, then it will happen with the receiver or the legal assignee or the trustee of the insolvent person, bankrupt person, because he is not he's insolvent, so he might have to bear some company expenses. But if he does not have money, so company will adjust the payments from dividends. In the dividend chapter also I have told you this point, that if you are on one hand you have to pay calls in arrears, and on one hand you are going to receive the dividend, and if you are insolvent and you don't have any money to pay calls in arrears, then whatever calls money is there, that can be adjusted against the dividend. So that adjustment is possible by having an official liquidator or a trustee or some receiver or some assignee. Okay. So that's why insolvent, see, as far as voting is concerned, undoubtedly, without giving any second thought, the insolvent member can vote. However, When it comes to any monetary transaction, that time we check his, monetary criteria, insolvency criteria. Yes, read the answer. Illustration 10.
Yes, notwithstanding that he has no longer any beneficial interest in the shares and the dividends are payable only to his trustee in bankruptcy, an insolvent shareholder, so long as he remains in the register of the company as a member, is entitled to exercise his votes which are attributed to his status as a member.
So long as he remains as a member in the register of members, he is entitled to vote, undoubtedly, as I said. So, all good case studies we are discussing on today on meetings chapter. 100% chances of coming in exam. Then the next question is by electronic means. So, this has actually solved the proxy problem. I was talking about this only. That not only you can watch the meeting electronically, but now you can vote also by electronic means. Okay, in the general meeting, you can vote by electronic means. And you will not believe it that if a company is a listed company having its equity shares listed on recognized stock exchange, then electronic mean facility is mandatory for such companies. Imagine. And if the company is having 1,000 members or more, then again electronic means facility is mandatory. So moral of the whole story is that if you are a listed company or if you are having 1,000 plus members, electronic means facility is anyways important for mandatory for such companies. So voting by electronic means can be done in general meetings. So electronic means is very easy point. You have to make sure that when you're voting by electronic means, all the cyber security norms have to be followed. Okay. There is an explanation too inserted which says that if you're voting by electronic means, that the company has to follow all the cyber security norms, all the communication, data disruptions, any kind of destruction that can be caused to the data, all those cyber security norms the company has to follow. You have to use a secured system. What is a secured system? A secured system can be anything like a hardware or a software device that can be avoiding unauthorized access or misuse of the data, reliable system, and it is suited for performing some intended functions, and all the security procedures have been adhered. So that's a secured system. So companies should conduct electronic voting by a secured system. Okay, so voting can happen by a secured system. How does the company exercises electronic voting? So let us see the procedure. A member of the company who have the right to vote by electronic means or on a resolution, and the company shall pass the resolution in accordance with these rules. Member can exercise voting by electronic means shall comply with the procedure such as the notice of meeting shall be sent to all the members by registered post or by electronic means. So notice can be sent by registered post, by courier. Then the copy of the notice will also be placed on the website of the company. Member can access that website always. Then the notice shall give all the details of how voting can happen, how a transaction can be discussed by electronic means. And the notice will indicate the manner in which the voting can happen by electronic means. All the login ID details have to be given to the members. Notice should be published 21 days before the conduct of the meeting in at least one vernacular medium newspaper and of course one English newspaper as an advertisement. And the notice should specify the date and the time for commencing e-voting. That means what is the date on which the e-voting will commence. So usually that date is very near to the AGM date. The time gap is only 24 hours. The notice will specify that. Then the cutoff date should be specified. Time of e-voting. So they have mentioned the time also. The facility for remote e-voting shall remain open for not less than 3 days. So it is close to the meeting, as I told you. and shall close at 5 p.m. on the day preceding the date of general meeting. That means 3 days before it will be kept open, and that 5 p.m. will be the last time. After that, the next day the meeting will be happening. So by till 5 p.m. your all votes should be registered through electronic means. So till that time you should vote. You should have voted by electronic means, because you will be having the copy of the notice, so you know what is the resolution to be passed. Okay. Then there is something called as block facility. At the end of remote e-voting, the facility shall be forthwith blocked. So blocking the e-voting meaning simply stopping it. So now members cannot vote further. Block facility. If a company opts to provide the same electronic voting system as to be used during the remote e-voting during the general meeting, then the said facility shall remain open or operational till the resolutions are considered and voted upon in the meeting, and may be used only by the members attending the meeting who have not exercised their votes through remote e-voting. So now those who are not using the e-voting option, they can go physically in the meeting and they can vote. This is very easy point. And I think I told you, chartered accountant, company secretary in practice, cost accountant, these advocate, these are the people who can appoint as scrutinizers. Okay, for the poll method, show of hands method, they can be appointed as a scrutinizer, and they shall be using transparent manner of counting the votes by electronic means. So even the votes which are counted by electronic means are in transparent manner. Such people, the chartered accountant, company secretary, should not be in employment with the company. They should be people of reputation like me. Okay. Then fair and transparent manner they have to follow here. They should not be in employment. They should be well versed with the act, well versed with the electronic voting system, etc. These are all the points that you have to keep in mind. Then you have to take their consent also, that the scrutinizer is willing to become the scrutinizer for the purpose of ascertaining the requisite majority. So it's not that the company wants to appoint a scrutinizer. You have to take the consent also of the scrutinizer. The scrutinizer should be ready to act as a scrutinizer. So then the counting of votes will be done by the scrutinizer. In 3 days of the conclusion of the meeting, all the votes will be counted. Then he will prepare a consolidated scrutinizer report. Underline consolidated on page number 7.54. The scrutinizer will prepare a consolidated scrutinizer report. And he may take help of the chairman. The chairman will also put his signature on the consolidated scrutinizer report. Very important line. That what is the process of counting votes? So you should say, by consolidated scrutinizer report, the votes will be all the votes will be written in the report. 2 witnesses should be there. Again, these 2 witnesses should not be in employment with the company. Scrutinizer should have access to all the member details. How will the scrutinizer count who has voted and who has not? So you should show him the membership register. Then scrutinizer will also maintain the register of all the members on his own personal capacity. He will keep the register of members in the safe custody. Okay, then he can keep it in the company office. He may keep it in his own office as a scrutinizer. The scrutinizer report will be published on the website of the company. It will also be published on the website of the stock exchange if the company is a listed company on recognized stock exchange. Then the results will be published even on stock exchanges of the on the websites of the stock exchanges. The report will also contain the facts that when the resolution was passed, what was the date of passing resolution, whether any resolution was withdrawn. Suppose you are voting by electronic means and suppose the company has withdrawn the resolution. So details about the withdrawal of resolution should also be written. And then poll will be demanded. I think I told you polling method. Who can demand poll? Members who are present in person or proxy, who are were allowed to vote, having not less than 1/10 of the total voting power or holding aggregate share sum of rupees 5 lakhs or such higher amount as may be prescribed. Underline 1/10 of the total voting power or 5 lakhs. Either in monetary terms, 5 lakhs, or you should be having 1/10 of the total voting powers. They can demand the poll. In case of any other company, so this 1/10 condition I counted where the company is having share capital, the 5 lakh condition. But if company is not having share capital, then only 1/10 you have to take. I think these are easy points. Then withdrawal of the demand for poll. Poll can be withdrawn at any time by the person who had made the demand. Again, here also scrutinizer has to be appointed. The same duties he will perform in poll method. See, scrutinizers are appointed in show of hands, by e-voting, by polling method. Basically, their job is to see that everything is happening transparently and proper counting they have to do. Then chairman will regulate the meeting. Scrutinizer will take all the records. Scrutinizer will prepare the polling papers. He will distribute the polling papers amongst the members. Even proxies are entitled to receive the polling papers. In case of joint holder, whoever is the first member, he will be first entitled to vote in the chronological order. Then polling paper, there is a form number MGT 12. Underline the form number. Polling paper form MGT 12. So scrutinizers details are important. Scrutinizer is important. Then postal ballot method. It is very age-old method. Section 2 clause 65 defines postal ballot as a means of voting by post or through electronic mode. So postal ballot can be used for by post or by remotely the shareholder is voting. Shareholder is not coming. He's voting remotely. Postal ballot. So you can use remotely by registered post, by speed post. You can send the postal ballot. And if you are voting by electronically, remotely, electronic means it can be something like an email. You can vote by email also. Again, here also scrutinizer will be appointed for counting the votes by postal ballot. The results which are declared by the postal ballot should be kept on the website of the company. So same provisions, mutatis mutandis will apply, as it is will apply. Then there is one condition written that following items of business should be transacted only by means of voting through postal ballot. So by postal ballot, what you can transact by alteration of the object clause of the memorandum, alteration of the association articles of association, change in the registered office, or change in the object of the company, issue of shares with differential voting rights, dividend, variation in voting rights of class of shares, buyback of shares. Just listen to me so that you can remember these transactions which can be done by postal ballot. Election of director by postal ballot, sale of undertaking or substantially the whole undertaking by postal ballot, extending loan guarantee, providing security in excess of the limit which are specified in 186 section. 186 section is the most important section in final CA, not in inter CA, intercorporate loans and investments. Tell me, are the voting methods clear, sir? Everybody's clear? Yes, sir. Yes. So you can relax for 2-3 minutes. Yeah, Trupti, thank you. You can relax for 2-3 minutes, then we can continue. And now I want to discuss some I think last lecture I said that I'll discuss some important things for auditing subject also, which will help you in scoring marks. So after the break, we'll just have a small discussion on auditing, how to study auditing, what all things you have to remember. So please don't miss that. So first we'll have a 2-3 minutes relaxation, then we will start. Yes, please pay attention, everybody. Let us begin. Sir, there are two important sections. First, I want to discuss that. Section number 112, which I'm expecting a question, and 113 also in the meetings chapter itself. 112 section talks about representation of the president and governors in the meeting. You tell me one thing. President of India, Draupadi Murmu, she holds close to 2 lakh worth of crores of shares, 2 lakh crores rupees, 2 lakh crores worth of shares, close to that. All the PSU shares, all State Bank of India, these, that, all government company shares are with in her name. Of course, it is not the money paid by her, it is public money only, but she is the caretaker of those shares. Governor of the states holds shares of government companies, PSU companies. Even they are the shareholders, but they can't attend the meeting, they can't come because of their seniority, because of their reputation. So they are not ordinary people, no? They are extraordinary. So they are of high caliber, the president, the first lady of India. So they can't come and attend the meetings. So that's why they can send their representatives at any meetings. Okay. So if it is any general meeting, then their representatives can be sent. And of course, their representatives will be appointed by these president and governors themselves only. The representatives who will be attending will have the same rights and same power, and even they can appoint proxies. So the representatives are not proxies. Under them, proxies can be appointed. Please don't make a mistake. Otherwise, you will say, sir, proxy is a representative of shareholder. So the representative of the president and governor is also a proxy. Not like that. The representative of governor and president, they are basically the representatives of the governor and president. Okay. Now, under them, proxies can be appointed. Under them, proxies can be appointed. So then they can appoint proxy, they can vote. And whenever the representative of the president and governor will be voting, it will be assumed that as if the president, governor themselves are voting as the member. So the law has given same status for voting as the law has given it to the president or the governor of the state and president of the country. So even the representatives will be exercising the vote in the same manner as the member of the company. So I'm marking this 1112, 113 important sections. Then the next section talks about 113 section, that is representatives of corporations, of the corporations meetings of the companies and creditors. So suppose you're representing a company. Now company is an artificial person in the eyes of law. Can a company come? Can a company come and attend the meeting? No, company is an artificial person. Company can't marry. Okay. Company can't go to jail. Company cannot be imprisoned. Company cannot go to hospital. Are you understanding? You have studied in foundation that artificial juridical person. So representative of corporation meaning the company's representative, or if it is a class meeting, then the class of creditors. Now if there, suppose there are 1,000 creditors, now all 1,000 will not come for the class meeting, their representative might come. So representatives of companies and representative of creditors, two people are there here. In the above section there was representative of the president, representative of the governor. Here also there are two people. So these people also, representative will have the same voting powers, same voting rights, including the right to vote, including the right to appoint proxy, vote by postal ballot on behalf of the body corporate which he represents. So whichever body corporate you are representing, on that body corporate's behalf, you can vote. You can vote. This is what the point has to say. Tell me, have you understood or not? 112 and 113 section are clear, sir? Very, very important sections these are. Yes, sir. Then I think resolution, I told you more than 50% simple majority, and special resolution, not less than 3 times the votes should be in favor as the votes against. Special majority. Special majority is 3 times the number of votes who vote in favor. Resolution, again, notice has to be sent. 21 clear days notice has to be sent. If it is a special resolution, special business is conducted, then explanatory statement has to be sent. All these points I have discussed. Okay, then there are some case studies, but I'm marking them for you to read for homework because now not much time is left. So illustration 11 and 12, you can read it for homework. I'm just going through the important points now. Resolutions passed at the adjourned meeting of the company shall be resolutions which will be treated as having been passed on the day when it was actually held and not only any earlier date. So resolution passed in the adjourned meeting will be treated as proper resolutions passed. That means votes which are passed by resolutions passed in adjourned meeting will be valid votes. Okay. And on that date, the resolution will be dated on the date of the adjourned meeting, not of the date of the earlier meeting. So if the meeting gets adjourned, if you see this example, the original meeting was scheduled on 23rd June. Adjourned meeting was adjourned and later on scheduled on 30th June. And on 30th June, 2 resolutions were passed. Then the said resolutions have been passed at the adjourned meeting, that is on 30th June, and not on the earlier date. So resolution cannot have retrospective effect. They will be having prospective effects. This is an important line. Resolutions will have prospective effects. Then minutes of the meeting, we all know that minutes have to be made. Minutes shall contain all the fair summary, correct summary of all the proceedings that took place at the concerned meeting. So minutes is important. All the appointments that are made in the meetings will be included in the minutes. Suppose you have appointed a director, you have appointed an auditor, you have to include it in the minutes of the meeting. Minutes can be prepared for committee meeting, board meeting. If it is for committee meeting and board meeting, then the name of the directors who are present in the meeting, their name should also be added in the minutes book. Then the chairman has the absolute power to sign the minutes book. Minutes shall be kept at the registered office of the company. If you are not keeping the minutes the way they are supposed to be kept as per the company law, then the company shall be liable for a penalty of 25,000 and every officer flat penalty of 5,000 rupees. If anybody tampers the minutes, do you do some fiddling or tampering with the minutes, then imprisonment can also devolve up to 2 years, along with monetary fine of minimum 25,000 to maximum 1 lakh, which is very important point. Mark this penalty important. Penalty for tampering with the minutes. If you are tampering with the minutes, then 2-year imprisonment is there. MCQ question. Penalty for tampering with the minutes. So minutes should be made from the start till the end. Signing of the minutes book. Chairman will sign the minutes book. The first and the last page should be signed. The in-between pages can be initialed by the chairman. If chairman is not able to sign, then any authorized person. Why will chairman not be able to sign? If chairman dies or due to his inability, then any director duly authorized by the board can sign the minutes. If chairman is not able to sign, minutes will be kept in the custody of company secretary or any authorized director at the registered office. Minutes should be preserved permanently. Important point. Not for 8 years. Books of accounts are for 8 years. Minutes should be preserved permanently. Important line. Then copy of minutes book of the general meeting. If anybody wants to see any copy of the minutes book, you have to pay 10 rupees for every single page. If you want to verify the minutes book of the general meeting, then you have to, any member can verify the minutes book, but you have to pay 10 rupees per page. Company can charge you less also, because printing and stationery cost can be less also. Member can request for a soft copy of the minutes. Not more than 3 financial year backward, you can go and you can request for a soft copy. Up to maximum 3 financial year backward, you can go preceding 3 financial years. And that soft copy will be provided free of cost. They will not charge you anything for providing soft copy of the minutes book. So annual general meeting, the first AGM should be held. Section 96 says that the first AGM should be held within 9 months from the close of the financial year. The subsequent AGM should be held within 6 months from the close of the financial year. The gap between two annual general meetings should not be more than 15 months. Registrar may further extend this period of 6 months to further period not exceeding 3 months. No extension of the validity period will be given for AGM if it is a first AGM. Extension for first AGM not granted by the registrar. Section 96 says that. Then there are case studies which you have to read. 9 a.m. to 6 p.m. should be the business hour time when AGM can be conducted. AGM cannot be conducted at the national holiday. No distribution of any gifts to the shareholder at the AGM not allowed. No gift distribution, nothing is allowed at the AGM. Then report of AGM, section 121, section marking important. Report of AGM. Report of AGM should be prepared in addition to the minutes book. Form number MGD 15, page number 7.86. Form number MGD 15 underline is the report of the AGM. It has to be filed with the ROC within 30 days of the conclusion of the AGM by paying necessary fees. The report should be signed. The report should be dated by the chairman. The report should have all the details: venue of the meeting, date, time, hour, chairman records, quorum present, any kind of business that was transacted, adjournment, postponement of the meeting, change of the venue, and other such fair summary, correct summary. If you are not preparing report, penalty is important. I have discussed this in class, regular lectures also. If the company fails to prepare and file the report within 30 days, it shall be liable to 1 lakh rupees penalty. And for continuing failure, 500 rupees for each day after the first day during which the failure continues, subject to maximum of 5 lakh rupees. And every officer will be liable to not less than 25,000. And for continuing failure, 500 rupees for each day, subject to maximum 1 lakh rupees. Then extraordinary meeting has to be called, section 100. So members can requisition, board can call, NCLT can call. These are the parties who can requisition the EGM. The notice of EGM should be sent by electronic mode, speed post, registered post. And again, the 21 days point will apply, clear days. I think I have discussed all the points of meetings. All the important points we have discussed. Tell me, have you understood or not? Everybody. Yes, sir. Perfect, sir. So meetings chapter, very important. See, we have discussed all important topics, okay? Audit chapter, accounts chapter, meetings, prospectus. These are extremely important chapters. So please revise them, study them properly. Order of chapters that you should prepare. So please note down the order. I can give you the order of chapters. You will always start with audit, accounts, and dividend. These three chapters carry 25 marks weightage minimum. Audit, accounts, dividend. First, do these three chapters thoroughly. 25 marks weightage. So this is one chunk. Then charge, prospectus, acceptance of deposits, and foreign company. This is the next chunk. So audit, accounts, dividend. Have you noted down? Please show thumbs up. Audit, accounts, dividend. Okay, then charge, prospectus, acceptance of deposits, and foreign company. These are the four chapters. Again, another 25 marks from here. At least 20 marks, 5 marks each. I'm counting MCQ marks also. So acceptance of deposit, prospectus, charge, and foreign company. Okay. Then share capital. Okay, share capital, debenture, and management and administration, the one which I was discussing, meetings chapter. Share capital debenture. Share capital debenture is one chapter, and management administration is one more chapter. So this is the next chunk. This will carry another 15-20 marks. So first category 25 marks, next category 20 marks, 45, plus this category another 20 marks, 65 marks. Company law weightage in your exam 70 marks. So around 65 marks I told you now. It will come from here only. And then there are some time pass chapters. What are time pass chapters? I'll tell you that preliminary definitions are given. Time pass chapter. You can read some important definitions like private company, public company, government company, small company, OPC company, dormant company, foreign company. All the definitions you can read. Yeah, I told small company. I said, Shashank, you're not paying attention. I said small company. Section 2, clause 85, small company. Then that LLP chapter you do. LLP chapter, it's in part A only. So these are time pass topics. So LLP preliminary, then some memorandum articles of association, maybe 1 or 2 marks question can come from there. This is the next chunk for 5 marks. So LLP preliminary and MOA, AOA, incorporation of company, total 5 to 6 marks weightage. This is the chunk. Tell me, have you understood the sequence? Have you understood the sequence for company law? Everybody? Yes, sir. Okay, now. Okay, very good. So now auditing. Let me speak for 5-10 minutes on auditing. See, I'm sure that you have nicely studied the subject of auditing, but what all things you have to study properly are important from exam point of view. Since in auditing, the major part of the paper will be only standards on auditing. So whichever book you are referring, you have to study standards properly. Okay, standards on auditing, SAs. SAs, more than 60% of the paper is only going to be standards. You take it as a word from me. I can write it on stamp paper and give you 60 to 65 marks, maybe 70 marks also. But I'm not going till 70, but I have seen that in my experience. I have seen that in November 2014, I still remember the question paper because in that attempt I had got a All India second rank student. He had got 70 marks. He was from Tamil Nadu. I still remember that question paper. 68 marks standards were asked. And if you don't trust, then you go and check November 2014 paper. And that time standards were not important because standards were having around 40-50 marks weightage. But the new syllabus modules now which are made are all totally standard based. Just like how in accounts you have accounting standard, in auditing you have auditing standard. I can write it on stamp paper and give you 60 to 65 marks paper is only going to be standards on auditing. So please do standards on auditing thoroughly. It is going to be a life savior. Don't leave even a single standard because they will ask questions from all standards. After doing standards on auditing, you can then study CARO, CARO, Company Auditors Report Order. Another 5-7 marks questions can come from CARO. Then you can study small chapters like audit of different items of financial statements. Then you can study audit of different types of entities. Whichever book you are referring, stick to that. So audit of different items of financial statement, audit of different types of entities. You have to study that. And then you can study bank audit, automated environment audit, auditing in automated environment, government audit, LLP audit, cooperative society audit. These are all small, little, everywhere they will ask 5 marks question, 4 marks question. So that you should study. So this should be your sequence: standards, CARO, then items of financial statement, then types of entities. Afterwards, you have to study bank audit, automated environment, government audit, LLP audit, cooperative societies audit. These are all topics you have to study. This way you have to plan your audit studies. Apart from referring to the notes that you have, I would request you to solve 3-attempt mock test paper and 3-attempt RTP in auditing. They are very helpful. Let me tell you, they are very, very helpful. And when you will prepare auditing for the last day, that 1.5 day, I think you have 4 days holidays for auditing, if I'm not wrong. Correct? If I'm not wrong, you have 4 days holidays for auditing as per the new timetable. Yes, sir. See, 4 days holiday you have. In lucky people. Now, if you have 4 days holidays, further what you can do, you can revise all module case studies. Like behind the module, they have given exercise questions, just like how we were doing in company law just now. Module case studies you should study. Since you have 4 days holidays, you can easily study all the case studies from module. Only the case studies I am saying. For the notes, you refer to the concerned lecturer's notes, whoever you have attended. But for behind, you have to study module case studies. That will really help you because you have 4 days holidays in auditing. I wouldn't have suggested you that. But since you have ample time, make use of it and study all the module case studies. Because see, if you will pass, we will be happy. As a team, we will be very happy that you cleared and you are our students. And this is all what we want from you, that you should clear. Your parents should also, acknowledge us that, okay, sir has taught company law. So then the students passed. So that is what all we want. Okay, good wishes. So tell me, any specific thing you want to ask me regarding law or auditing? Anything specific you want to ask? Anything that comes to your mind? Or anything else you want me to suggest you? This is what best I can suggest you in the limited frame of time. Anything else you want to know specific? Then I would want to thank to Trisha classes for giving this, revision lectures to you all people so that you could attend them, even though it was a short synopsis of the chapters that we were discussing, but still I'm sure it is really helpful. So thanks to Trisha for organizing such type of things. I'm highly, having regards for Gopal sir, and it's been a long association with the company, and I want to make sure that whatever I do with them, I deliver the best to you. Yes, one more question is coming up. Should we write and study audit? Yes. Hriday, yes. Write and study. You have ample time, 4 days holidays. You should practice writing practice of case studies according to essay. Write the essay number, write the heading, then write the content, then write some 2 3 points, and then close your answer with a proper conclusion. So writing practice is important. Yes, I will say yes, you should write case studies. And you do mock test paper solving, that also in writing, no verbal solving. This is not verbal novel subject. Okay, you have to solve it. Do writing practice as much as you can. You have ample time. Today also, if you start studying, let's count today is a 0 day. 28th March is a 0 day. You still have 32 days. You can change the whole game in 32 days. If suppose today you say, sir, I don't know anything of CA Inter, I've just attended coaching, that's all. Today also 0 day, if you start 6 subjects, 32 days, 5 days per subject, easily you can prepare. Full day you can only study. I can tell you, if today is a 0 day, you take an NPV calculation, year 0. So today is day 0 for you. If you start from today also, in 32 days, you can turn the charts completely. Tell me, is it clear, sir? So I hope that all of you pass CA Inter, and we will meet again. Yes, sir. And we should meet again. We must meet again in CA final. I have a subject in CA final, my favorite subject, auditing. So I can, we can again learn auditing. In auditing, case scenarios are MCQs are increased. So from where we can get those MCQs? Yes, Shushmita, thank you so much. Case study scenarios, you can refer module. In module, they have given case study scenarios. Answering to Yashwant, your question, case study scenarios, you can study from the module. Module, they have given integrated case studies. You can refer some past papers also. RTP, they have given case study scenarios. There you can study from. Small MCQs I am posting on a daily basis. You can solve those also. But the big case study MCQs, you can refer module. Yes, sir. You can refer module and RTPs for that. In behind every chapter, they have given case studies. Yeah, Sushmita, thank you so much for consideration, acknowledgement. Okay, sir. So with all good things, I would want to wind up the classes. Thank you so much. I hope you enjoyed the sessions. Bye-bye to everybody. Thank you so much. And my best wishes for exam. Do well. I will see you soon in final CA. Yes, within next 6 months, everybody should be in final CA. Okay. Thank you so much. Madhav, bye. Bye-bye, Shashank, Srinidhi, Sushmita. Thank you. Bye. Fantastic. Bye-bye. Namrata, bye. Thank you. Bye, Pooja. Bye, Pujita. Thank you. Isha, thank you so much. Bye-bye. Thank you. Thank you. Bye, everybody. Bye-bye. Thank you so much.